Welcome to Understanding Statelessness, sponsored by the ABA and the Commission on Immigration. To receive CLE credit, you must attend the entire program. Partial credit is not available. Please click on all the participation verification alerts to confirm your attendance. After the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit, providing your bar information as requested, and submit. Once your attendance is verified, your certificate will be emailed to you. Moderating the program today is Stephanie Baez. Stephanie is pro bono counsel for the ABA Commission on Immigration in San Diego, California. Stephanie, you may proceed with the program.
Thank you. I'd like to begin by briefly introducing today's wonderful panelists. Joining me on the program are Samantha Sitterly and Karina Mbartsumian-Clow. Samantha is United Stateless's first staff attorney, and she resides in Boulder, Colorado. Karina is located in Philadelphia, Pennsylvania, and she is a founding member and the executive director of United Stateless. The extensive bios of both of our panelists are online and in the materials provided with today's webinar. So with that, I'm going to go ahead and turn it over to the panelists to begin.
Thank you, Stephanie, and thank you everyone who has joined us today. We're very excited to have this presentation. So this presentation will cover a number of topics. We're going to be discussing, this presentation is called Understanding Statelessness. So we're going to be discussing what statelessness is, what it means to be stateless, the United States stateless context, our story as an organization, United Stateless, and we'll go also a little bit into screening for stateless people, possible relief and advocacy updates. And I also do want to point out that we are planning a second presentation, hopefully next month, that will go into a lot more detail of actually representing a stateless client. But today we'll learn more about the background of statelessness and that other context.
Hi, everybody. My name is Karina Mbartsumian-Clow. As you know, Samantha and I are part of United Stateless. We are a national organization led by stateless people whose mission is to build and inspire community among those affected by statelessness and to advocate for our human right to nationality. I have been stateless in the US since I was a child. I came to the US at 8 years old in 1996. I am now almost 35 and I am still stateless. And thank you for joining this training and webinar and getting your CLE credits. We're really, really grateful to be here. But we wanted to start from the beginning. And so I also want to raise that it's completely normal not to know what this is. What is statelessness? Who becomes stateless? Why is it happening here? I myself didn't know I was stateless until I was 24. So it's a topic that is largely misunderstood, unknown, and underreported. And we'll also get into why United Stateless exists. So the definition of a stateless person is a person who is not considered as a national by any state under the operation of its law. That is a definition that can be found in the 1954 Convention relating to the status of stateless persons. We'll get in more about those conventions again in a second series, but people like me are sometimes often described as citizens of nowhere because there's no country that recognizes us as their own. Either we were born stateless or our nationality or citizenship has been stripped from us. And it kind of gets into this area of, well, what is citizenship? Why is it important to have it? We live in a world where every country is governing bodies that have a border, and those governing bodies get to decide who it gets to have citizenship, how it's acquired, and what rights do you get with that citizenship. And of course, it kind of varies from country to country, but in having nationality or citizenship, you have access to rights. You have access to a legal identity. You have obligations to that state, right? Hello, tax season. Civic engagement sometimes in certain countries are a requirement, along with various states have military service. You are protected by that state, and you have a sense of belonging and identity. This idea of citizenship and nationality kind of started post World War II. World War II ended in September 1945. The UNHCR, United Nations High Commission for Refugees, was formed in 1950. And during that time, all these great thinkers and, leaders came together and kind of had to decide, what happened. We had one of the most biggest atrocity crimes ever committed in history. This war has, rampaged the entire continent, basically. And here we have these thinkers coming together for the UN Convention on 1954. And there's also subsequent convention in 1961. I'm sure some of you are familiar with refugee conventions that happened around that time. Nevertheless, these world leaders established UNHCR, and those three mandates are to protect refugees, stateless people, and internally displaced people. And we see also Eleanor Roosevelt here pictured with the Declaration of Human Rights that is essentially a premise, a foundation of what simply by being a human being on this planet, what rights do you have access to and you should be guaranteed. And this is the perfect world that we're striving for, centered on peace and equity. And the 15th article says every single person has a right to nationality, because we live in a world where each country has to recognize who is in their country and give them protections. And we'll get into why statelessness exists, because that's when countries don't do that. Those two conventions I've mentioned, 1954, define statelessness. It sets out rights to which stateless people are entitled to, which is employment, housing, travel, facilitated naturalizations. And the core principle is that stateless people should be treated fairly. 1961 convention goes a little deeper into how states, the nationality laws that exist, need to avoid the creation of statelessness at birth. And they wanted to also prescribe standards to how you deal with the administrative, side of how do you deal with when you do find someone in your country that is stateless. Just pointing out, compared to the refugee conventions that has about 147 states signed, there's a lot less for the stateless conventions. And I think it just adds to how much this is so unknown and unheard of. The way countries are giving citizenship, or how you are, can attain citizenship, is simply largely by two ways. Jus soli is, you're born on soil, you'll automatically get citizenship. That is true here in the United States. As you can see in this map, kindly provided from Reddit, citizenship, it shows you like a picture view of like the blue states of countries in the world that do provide nationality that directly, versus the jus sanguinis countries provide citizenship through blood, or you inherit what your parents have. You become a citizen of a country if your parents have a citizenship. And in some cases, you can naturalize, and that's by marriage. Certain countries allow that through long-term residences. And of course, countries also are able to grant citizenship upon discretion. So think like high-profile people. And there's even more boundaries to that. There are about 24 countries in the world where women are unable to pass citizenship equally to men. And of course, there's a little bit varying degrees from that. The countries in the red have created the greatest risk of this and do not allow hardly any leeway. Orange allow women to pass in some circumstances, and yellow are a little bit more, they're a little bit more leeway. But a father is the only one is able to pass nationality to their child in this country directly. And you find yourself born stateless, or you found yourself a mother giving birth to a stateless child, where the laws of the country where the father's from do not permit or allow that country to give nationality in circumstances where the father's unknown, or you are a product of rape and the father does not claim you. These countries also, some of them have administrative obstacles. And again, United States, you're born in a hospital, you're automatically given that birth certificate right there in that hospital. A lot of countries, there are some barriers to that. And then, of course, there's some countries where the father's just unwilling to claim their children, and that's the rise of childhood statelessness. And the next slide here, I'm going to pass it over to Samantha to kind of give her description of this legal framework.
Yeah, this quote comes from a landmark case, Trop versus Dulles, 1958. The circumstances were that the United States, as a punishment for desertion during World War II, in fact, for a soldier, stripped the soldier of his U.S. citizenship. The court in this case found that that was a violation of the Eighth Amendment against cruel and unusual punishment. And I just really love this quote because I think it really accurately articulates what is at stake when someone loses citizenship. Citizenship is the right to have rights, and the loss of citizenship subjects the individual to a fate of ever increasing fear and distress. He knows not what discriminations may be established against him, what prescriptions may be directed against him, and when and for what cause his existence in his native land may be terminated. He is stateless, a condition deplored in the international community of democracies. Really strong language from Justice Warren from this really important case. And later in the program, I'll explain where that comes into play in the US legal framework.
Thank you, Samantha. And the root of causes, or the root cause of all statelessness, is based on discrimination. And it happens through the vehicles are conflicting or discriminatory nationality laws. Before the Rohingya genocide, Burma did pass nationality laws that specifically targeted their citizens of Rohingya descent. And you've seen this in every war, and oftentimes it is a precursor to atrocity crimes. Wars, border disputes, state successions, migration and genocide, and of course, administrative obstacles. Some facts here, 15 stateless people worldwide. That is an estimate, and largely it is hard to estimate how many stateless people are within countries or states, as certain countries are perpetuators of statelessness. A child is born stateless every 10 minutes and is often a prelude to atrocity crimes. We've seen statelessness before the Holocaust. We've seen statelessness before the Armenian genocide. We see states stripping protections from their former citizens and then being able to have more greater leeway in some of these atrocity crimes. Oftentimes we've always, I've heard, and I at one point believed, because I had to discover my own statelessness, I thought this was something that happened in the past. But rather, and these are some of the big striking headlines this past year, statelessness continues to happen around the world. And sometimes it's specific incidences where the country is discriminating against someone's gender or sexual preferences, or it is oftentimes happening when stateless populations such as the Rohingya are continuing to struggle for recognition. And where does that responsibility fall? And that responsibility falls on each state. And that's kind of what the international human rights framework talks about and protects. And, in the United States, it's kind of similar to what people experience as abroad. So this would give you a context. But I felt like it's important to also highlight that, the US citizenship at one point didn't expand and include people that are born in the United States based on their race and ethnicity. The descendants of enslaved people were not able to access citizenship until 1868. 1924, President Coolidge passed the Indian Citizenship Act. Here he is pictured in the middle with the Osage tribe. And of course, we've seen incidences of statelessness during the 1942 to 1945 Japanese internment camp, or excuse me, internment camp of Americans of Japanese descent. And today, what we do know about statelessness is that there's an estimate of 218,000 stateless people in the US. And we are from over 30 different countries and territories around the world, and we reside in all 50 states. And the kind of issues that stateless people face in the US is that there is no legal framework to define, protect, and assist stateless people in the United States. Largely misunderstood, underreported, and unknown, even by stateless community. No official data from the US government in quantifying statelessness. Now, we do know that stateless people are able to and have been able to resettle in the US with refugee protections, and that's great. That's phenomenal that stateless people are able to receive and find a pathway to citizenship. It is a human rights violation, and it's a prelude to barriers and repeated trauma. And without access to a legal identity, you have a hard time getting a job. You can't answer the question, can I see your ID? Or what country you're a citizen from? You have limited upward mobility options. Luckily in the United States, there are protections for children. And so as a stateless child, I was able to go to public schools and receive education without some of those real barriers that exist in other areas of the world. But applying for colleges and getting any type of support became really difficult. There's no line at the DMV I could go to get an ID. There's a lot of mental and physical health vulnerabilities. There's long family separation, repeated and prolonged detention. We have found you're left unprotected. The country that you thought you were born in or the country that you came from doesn't recognize you, so you're unable to get any consular or embassy protection. And most significantly, you can't directly adjust, and yet you're unable to leave. But this isn't where the United Stateless story or the story of stateless people in the US ends. We started as an organization by those directly impacted. In 2017, here on the left-hand side, we met. All of us are stateless. All of us came to this country varying ways. Some of us were foreign exchange students that realized the country we were from stripped us from any protections. Some of us came here on asylum. Some of us migrated, surviving genocide. And we are also, what's striking to me, minorities in the countries that we're from. And we grew and expanded United Stateless because we needed to become empowered by our stories in order to create change, in order to start talking about it, in order to do these presentations with a room full of attorneys, to start paying attention to the importance of screening for statelessness. And one thing that we really center in our community, in our organization, is healing. We spend a lot of time, we've partnered with the Centers for Victims of Torture, CVT, that helps us, resilience training, helps us to provide peer-to-peer support in order that we're empowered enough to educate and raise awareness. That's a big pillar. Educate and raise awareness about something that it kind of doesn't make sense. It doesn't make sense that we have people in this world that don't have citizenship. It's bizarre. In order to do that, we center on advocacy. Our voices are part of the global movement around addressing this issue. Statelessness exists in every country in the world. We are the only organization in the United States that focuses on statelessness, but there's organization like ours in every region or country. We engage in research and student engagement to increase the understanding of statelessness. And we also provide stateless services, which is what Samantha will talk about more later. This is a program that we've partnered with HIAS and UNHCR, and we are really grateful for their ongoing support because we were able to get a lot of the attention of the administration. In December of 2021, we're really fortunate that the Biden administration took notice of this issue and have committed to enhance protections within the already existing legal framework. And some of the things that we've asked is for, ask for removing statelessness or considering statelessness in terms of barriers when adjusting status. I have been married to my US citizen husband 10 years this April, and not until this past year, where we'll get into that later, but for a long time I couldn't adjust my status based on my marriage to a US citizen because I had a final removal order and I needed to conduct a reentry, leave and come back, and uh, I couldn't commit to those requirements, which left me unprotected. And there's many other members like ours. And that was one of our major asks. We also asked the administration to help release stateless people from detention, lesser reporting requirements, and ensure that all stateless people have access to an employment authorization document.
Um, Thank you so much, Karina. So we also have been working on a number of other advocacy efforts, including in the US Congress. And we were very excited to announce this past December that Senator Cardin and Representative Raskin introduced a bill, the Stateless Protection Act, which would extend permanent protections to stateless people living in the United States. This is our long-term solution. This is a continuing problem, and we truly believe that this is our future. We've established that this is the problem, and we urge all of you to join us in this fight. Call your congresspeople and ask them to support this bill. Here at United Stateless, or USL, the services that we provide are legal services, including referrals to a pro bono network of attorneys who can provide all kinds of legal support. And when we do make those referrals, we are able to mentor and support attorneys who take cases. So if that's something that you're interested in, we do provide support if it's something that you don't have experience with. As Stephanie mentioned at the beginning of the program, I'm the first staff attorney with United Stateless. So in this role, I am able to provide direct legal representation to the members of our stateless community for the varying issues they have, although my expertise is in immigration law and most of the legal needs do tend to be within immigration. We also provide social services. We have an excellent case manager, Ivan Medina, who provides assistance connecting our stateless members with housing, income, employment supports, and we even have a stateless relief fund, which is direct cash assistance that we can offer our members. So now I'm going to get into when and why you should screen for statelessness when you're representing clients. So here's a list of a non-exhaustive list of ethnic communities that are more likely to be stateless, as Karina mentioned. So often, stateless people tend to be minorities in the countries or regions where they come from. And this is also, and so this is things that are caused by largely discrimination, but also dissolution of nations or political structures, generalized chaos. Again, this is not an exhaustive list, and we should be thinking about statelessness as a continuing human rights violation, a continuing issue. For example, not on this list, just a few weeks ago or months ago or so, Nicaragua denationalized a number of former citizens of Nicaragua because of political persecution and discrimination. And so obviously terrible. Those people are now stateless or seeking citizenship in countries where they are not from. And we do know that denationalization or denial of citizenship is often a precursor to atrocities. So we're watching that situation closely. Also, as we mentioned, the United States does a pretty good job, a very good job, of preventing statelessness for people who are both born in the United States and to US citizen parents. So we often see stateless people that are present in the United States coming from other countries. So they often appear as non-citizens in our immigration system. And they appear in just about every way that you can think of within the immigration system. They enter legally or unauthorized, visa overstays, lapses in their status or their travel document validity, applications for asylum that are denied or approved, and refugees who are resettled become permanent residents, loss of status, perhaps because there are criminal convictions that then make them no longer eligible for the status that they previously held. And again, this stuff we can get into a little bit more detail in our second presentation in the series. There's also international adoptees, unaccompanied minors, people who are receiving DACA, and other people who entered as children and never naturalized for whatever reason, maybe never had access to permanent residence in the first place, or were unaware that they were not citizens until much later in life. We also see, unfortunately, prolonged detention and prolonged orders of supervision, meaning while a person has been, determined to not be legally present in the United States, they can be detained, and then there are many attempts to remove that person, but there's nowhere for them to go. And then, best case scenario, they are released from detention, but perhaps kept on orders of supervision, sometimes for decades, sometimes for the rest of their lives. So in immigration court, we do see a number of issues where statelessness comes up. So for those of you who do not practice immigration law, a notice to appear is the charging document which initiates proceedings in immigration court. And that notice to appear includes a number of allegations. And those allegations include, for example, you are not a citizen of the United States, you are unlawfully present, you are a citizen of X country. And there is required that there is a nationality or citizenship determination in those immigration proceedings. And so when a person is stateless, it must be asserted that there is, in fact, no nationality, there is no country that person belongs to. And sometimes then the court will determine the country of last habitual residence instead. The court will then also, once pleadings are entered, right, so that the person is not lawfully present, for example, and it's found that the person is removable, then the immigration judge must designate a country for that person to be removed to. This has been litigated at the US Supreme Court in JAMA versus ICE, that citation there. And it's also codified in the statute, the Immigration Nationality Act, section 241, subsection B. And this is the in order how the court determines the country to which the person will be designated to remove, whether or not they can actually be removed there. And this is in order. So number one, the non-citizen gets to choose that country. If they decline that choice, or that choice is inappropriate for whatever reason, the second is the country where the person is a citizen. Third, the country where the non-citizen has a lesser connection, for example, the country where they were born or where their parents are from. And then finally, any other country that will accept that non-citizen. And what we see with stateless folks is that that list is exhausted and there's no country at the end of those four options. An order of supervision is when an individual has a final order of removal, which is what we call deportation, final order of removal or deportation. And for whatever reason, it is impractical or impossible for that person to be removed, for that final order of removal to be executed. And there is the statute, the Immigration Nationality Act, that same 241, requires that when that is the circumstance, then they must be under order of supervision. And what that order of supervision looks like is a lot like a probation officer or parole. There are regular check-ins. Sometimes there's something like ankle monitor or phone apps that track that person's whereabouts. They have to ask permission to leave the state if they want to travel, even for short visits. If they want to move, they also have to ask permission. But the one bright side is that under an order of supervision, a non-citizen is authorized to work or to request a work permit. And sometimes this is the first time the person has had any form of ID in their lives. And so that having that work permit can open a lot of doors. When a person is stateless and has no options for relief, this order of supervision can be indefinite. And we do have a number of people in our community who have been on orders of supervision for decades. Um, Individuals, non-citizens who are in the country without authorization, of course, can be detained. However, there is some case law. The United States Supreme Court considered this in 2001, that when there is no foreseeable possibility that an individual can be removed, that that final order can be executed, the United States has to um, justify with some really compelling reasons as to why they would keep someone for longer than 6 months. So if there's a stateless person who is in detention with a final order of removal for longer than 6 months, attempts to deport have been unsuccessful, um, uh, advocate or the person can file a habeas corpus petition and have them released. Very likely they will end up on order of supervision, but released from detention. So I want to talk also about the particular obstacles and issues that stateless individuals face. So one option for immigrants attempting to get lawful permanent residence in many cases is what's called a consular process. And this was something that Karina alluded to earlier. There are some circumstances where an individual must leave the United States, go to their own consulate and complete an interview and processing abroad, and then can return with lawful status, usually as a permanent resident. This, of course, is not an option for individuals who have no consulate, who have no country to which to go back to, or have no travel documents and have no ability to get on a plane or travel across country borders. We also see when folks are without legal status and without ID and without work authorization, they are living in poverty and struggling to get by. And of course, many local laws have some criminal statutes that criminalize things like loitering, camping, those kinds of things. And of course, there's things like petty theft, document fraud, um, falsifying documents in order to have something to prove who you are or to attempt to get work. We also see things like folks who entered as children especially, believe that they were a U.S. citizen until there's a circumstance in which perhaps they're trying to get a passport or they get into legal trouble and find themselves in immigration detention or immigration removal proceedings. And this can also be a really big problem because the immigration statutes are quite harsh for an individual who claims to be a US citizen for any kind of benefit. And the exceptions to a false claim to US citizenship are quite narrow and probably would not apply for a stateless person who believed that they were a US citizen. Furthermore, applying for any kind of immigration relief, you've got to prove who you are. If you don't have those documents, that is a major obstacle. Furthermore, also, again, those folks who are living in poverty or are not able to put their name on a lease or a mortgage, sometimes do not have a permanent address. Our immigration courts and immigration administrative systems use the mail pretty much exclusively, and not having a permanent address to receive or send mail from can be a major obstacle as well. We also see folks, some stateless individuals who in fact don't want to be in the United States anymore. They don't want to stay here. They would like to go back to where they came from, or perhaps another country where they have some ties or interest to go, and they can't. They cannot go, even if they wanted to, even if they want that deportation order to be executed. It's impossible. And also there's a mechanism called voluntary departure in immigration court, which allows the person to leave on their own instead of have a deportation executed on them, which is, sometimes creates benefits for the future if there ever wants to be, if the person ever wants to seek any other type of relief. That voluntary departure option is not available for them. And finally, the US government also, just like the regular population and just like the stateless population, is largely unaware of this issue of statelessness. So we do see, confusion or misapplication of the law, towards people who are stateless. And that can, of course, be frustrating and upsetting for stateless people. So we do have, seeing some bright spots in the future. There is, oh, I think I missed a slide. Yeah, sorry. So I want to talk a little bit about asylum. And again, I don't want to overwhelm folks, and we will get into this a little bit more in our second in the series, but I think this is really interesting, talking about statelessness itself as a form of persecution. So asylum is the inability of someone to return to their country of origin or last habitual residence because of fear of persecution or experiencing persecution in the past. So we strongly believe, and it's in international law, that statelessness is a human rights violation. And we see statelessness in a couple different ways. There's denationalization, or the involuntary loss of citizenship, and then there's the denial of citizenship due to discrimination based on an ethnicity, or nationality or country of origin. And there is the case law, Sturba versus Holder, which is a Sixth Circuit course from 2011, said that statelessness alone is actually insufficient to establish persecution for purposes of asylum. And there must be a discriminatory or persecutory reason for why that person is stateless. And there's a nexus requirement in asylum law that there has to be a persecutory reason for this person's status. And so that's where we see denationalization or the denial of citizenship based on discrimination. Those can be compelling circumstances that can establish eligibility for asylum. However, again, we at USL strongly believe that statelessness is always a human rights violation. It's always persecution. Think back to that quote from Justice Warren in Trump versus Dulles: living as a stateless person in any country is abhorrent and terrifying. And as we discussed, the problem is for more than just harassment or discrimination. It really is the loss of all of your rights. I also want to point out, and this may be surprising or confusing to some folks, that the impossibility of removal, or the lack of the ability to get a travel document, or the lack of having citizenship, or the lack of the ability to even establish a country of removal effectively, is technically irrelevant to the question of whether the person is eligible for asylum. It's a totally separate consideration. However, statelessness as a particular social group, and so that's one of the basis of asylum. If you are persecuted on account of being a member of a particular social group, being a stateless person or a member of a group that is denied state or citizenship, that should certainly be asserted. Statelessness itself as a type of persecution should be asserted, and we also could assert things like statelessness is persecution on the basis of national origin or even political opinion, protected grounds. If this doesn't make any sense to you because you don't practice asylum law, don't worry about it, but you should join our second training and we can get into this a little bit more. Finally, also, when somebody cannot establish eligibility for asylum, they may also be considered for withholding or removal or protection under the Convention Against Torture. This basically means that the person um, will be ordered removed, but that order will not be executed because of either persecution in the place um, where they are about to be removed, or because they will be tortured, or it violates some other type of international convention against torture. And again, denationalization, and I think we can assert living as a stateless person, is a form of torture under the Eighth Amendment, which was established in that Trop versus Dulles case in 1958. And if you have, cases where this is ringing a bell for you, I'd be so very happy to talk to you about this, mentor you about it. We feel it very strongly that this should and can be asserted in asylum. And so, apart from asylum, there may be some new promises in those non-citizens, those stateless individuals who are seeking permanent legal status in the United States, including a potential relief called parole in place. And this is a shout out to David Benyon of the Free Migration Project. David represents Karina in her immigration case and asserted that she was eligible for a parole in place option and successfully got it, which is super exciting, especially because I think most immigration practitioners would, at least this is the first time I had heard that this could be applied to anything other than a military family. Usually parole in place is only available for veterans and their immediate family members. And what this does is basically create a legal fiction that somebody entered the country legally so that they would not have to then consular process. They wouldn't have to leave the country, do some kind of interview at a US consulate abroad, and then re-enter. And so this is really, if you look at that statute, and this is the Immigration and Nationality Act 212, D5A, it doesn't say anything that it's limited to military families or their veterans. It's up to the Attorney General to consider, compelling case-by-case humanitarian circumstances. So if this also sounds like a case that you might have that maybe this could work in, I do urge you to reach out to me, and I'd be happy to discuss more. This is a really exciting, promising potential option for some folks. We also work on a number of cases for motions to reopen or joint motions to reopen. This basically means where somebody has a final order of removal, and their court case has already been completed and they lost. If there are changed circumstances, and that could be a lot of different changed circumstances, advocates can move the court to reopen the case and reconsider. And a joint motion to reopen would be asking the Department of Homeland Security to join in that motion, either because it's in the public interest or in the government's interest. And then also the stateless protective status is something that we are, as we previously mentioned, working on lobbying the US government to pass that legislation, the Stateless Protection Act, to provide a specific type of status for stateless individuals. At this time, there are not any special protections for stateless people. And so if you are an immigration practitioner or you work with immigrant populations, you should screen for basically any potential option. Again, and also like we mentioned, not only is there no special status, there's also not even a federal definition. They don't keep, the US government does not keep any kind of specific data on this issue. However, we are working on that and advocating strongly to urge the government to in fact do that. And as we mentioned, Secretary Mayorkas did make a pledge in 2021, and we are hoping that that comes down soon. Finally, I just want to point out it is very traumatic to learn that one is stateless or to live as a stateless person. And because there are no special protections for stateless people, Um, when you are representing a stateless person, it's important to manage expectations from the beginning. All of immigration processing is quite lengthy, um, and sometimes we see just incremental victories. And so it's important to keep in mind that it's always possible to lose and to um, or those victories might be not as grand as we hope for. What we see in this population, and what I see very commonly in my work directly representing stateless individuals, is a lot of hopelessness. Um, you know, like I said, we do have a lot of folks who've been under order of supervision for decades, and they really sort of given up. Um, so it's important when you are representing a stateless person to keep that in mind, to maintain sensitivity, and you know um, to be supportive and understanding of that trauma of living with statelessness. Um, and also, some folks have had some really negative experiences with the immigration enforcement authorities. And so if it's ever possible to accompany folks to their ICE check-ins. And then finally, when folks are feeling that hopelessness, that trauma, that desperation, it's really important to connect to community. As Karina mentioned, you know, a lot of people don't understand that they're not the only ones. So it's important to encourage them to know that they are not alone and to join us. And United Stateless has, not only do we provide services on an individual level, we also have a community. We have regular community calls supported by by CBT, where stateless individuals can communicate and talk about their own stories together.
And hello,
We are
everyone. I'm
wrapping
just
up
going to
here.
pop in for, oh, I'll just pop in. I know that there's a few slides still to go, but as Samantha is wrapping up the presentation, I just wanted to remind the audience that you can submit your questions via the Q&A feature on the webinar interface, and we'll turn to those questions in just a few minutes. As Samantha wraps up the presentation, please feel free to enter your questions in that Q&A box. Thank you.
Yeah, just to conclude, and then we'll take those questions. Remember that a stateless person is not a citizen of any country in the world, referred to as a citizen of nowhere. They exist in very large numbers all across the world and within the United States. Um, if you are a member of the US government or foreign government, if you are in a law firm that deals with immigrant populations, make sure they're aware of this issue, consider statelessness, incorporate screening into your intake process. Um, and you can also always consider referring clients to United Stateless. We are fully pro bono. We provide those stateless services, and we do have that those community calls. So even if they already have representation, perhaps those individuals would like to connect with other stateless individuals, and we do have space to do that. If you would like to learn more, we will be distributing, if it has not already been distributed, a sheet with more resources. But you can follow us on social media. If you have a case that you would like to refer, you can email us at intake@unitedstateless.org. General inquiries to info@unitedstateless.org. You can also visit our website. You can join our Google group. And of course, we urge you to donate to our Stateless Relief Fund, providing cash assistance directly to our stateless individuals. And what I did not include here, but we should, is you can also urge your representatives to support the Stateless Protection Act and make legal change in favor of stateless protections. But that is all of our presentation. Thank you so much for listening and joining us. And I think we can take some questions.
Great, and thank you so much, Karina and Samantha, for this really important and informative conversation. It's really been a fascinating discussion so far. One of the questions that has come in is, if there are no special protections for stateless people, then what are the benefits to identifying someone as being stateless? And are there any positive resolutions when statelessness is identified?
Yes. Um, there's a number of reasons why it's critically important to identify statelessness. Um, First of all, for example, if the stateless person is in immigration proceedings, it's very important to establish that they do not have citizenship in any country early on, especially at that pleadings stage. And perhaps if that person has a claim to asylum, statelessness will potentially be a basis for asylum eligibility, or at least it should be alleged. Furthermore, there's that parole in place option, which has been successfully worked in at least one case. And so those humanitarian considerations is also important to identify statelessness as a compelling factor to consider for parole in place, I should say, is discretionary relief, meaning that it doesn't, the government has under no obligation to approve. It really is a matter of discretion. So when you do have those compelling humanitarian circumstances on top of the fact that this person can't go anywhere, right? It's in everyone's interest to approve those kinds of discretionary relief.
Okay, thank you for that answer. And another question is, what are some of the biggest non-legal needs of stateless people in the United States? And particularly some of the biggest non-immigration related needs that people might have.
Karina, would you like to answer that one?
Thank you for that question. Some of the non-immigration needs stateless people have are financial support. Oftentimes, we have members in our community that are vulnerable to housing insecurities, inaccessibility to healthcare, including mental health care, and just need that kind of support. Oftentimes, they are ineligible for any state, local, municipal, or statewide, including federal level support because they don't have access to an ID. So we rely on private funding to provide that kind of support for our members through the Stateless Relief Fund.
And how do other countries consider stateless people who are living within their borders?
Karina, I'm going to let you take that one too.
Okay. Um, well, luckily, I think it's interesting to, the United States is a birthright country, and the fact that this exists is very rare. So it's interesting to look at France and the UK and what they've done and how they have supported. France actually adopted stateless status determinations, right? And adopted the definition of statelessness and protections for stateless people a year before the conventions. In like 1953, the first convention was 1954. And that's the kind of movement that is the premier, and hopefully more and more states can be able to fully protect. We do see in certain countries where statelessness is by descent, and you see communities that have inherited statelessness dating back 3, 4 generations, and they're also of a certain minority group, and the state that they are living in for the past 4 generations has not passed any specific protections for them. And that's where the global stateless movement and the advocacy around here works. And I know that there's a continuation of the I Belong campaign launched by UNHCR Geneva that is reformulating into a global alliance movement to address this issue. And what needs to happen is awareness raising across all fronts, but more states that have passed protections for stateless people, specifically Kazakhstan a couple of years ago completely eradicated statelessness in their country because they had really generous, and I mean generous in a sense that equal to what the standards are. And we want states to help push for other countries to adopt these protections. And the United States is capable of doing that. And I think it takes also directly impact organizations to work with government entities to push things forward. So I guess to answer your question, a bunch of different things. You see like countries like Kuwait that specifically target their stateless Badoon communities. And so it's something that the more we talk about, hopefully the less and less unknown it is. And just seeing a couple questions that came in too. All donations to United Stateless are to tax deductible. All of our donations are coming through uh, directly will go to our stateless relief fund. And just to share, it helps members with housing, mental health insecurities, and hopefully more and more fee support. Some of those fees can be quite costly. So, thanks to Samantha and Yvonne's leadership in our stateless services, we're able to identify the specific type of needs our members need.
Fantastic. That's great to know, and I'm sure has a big impact. One of the other questions that came up, and Samantha, I know you touched on this a little bit, but maybe you could elaborate. If someone wants to take on a pro bono case to help advocate on this issue, but they don't know much about immigration law, what kind of mentorship would you offer to those people?
Yeah, absolutely. We do offer mentorship. We are extremely grateful when anybody is willing to take on a pro bono case. There's a lot of situations in which we either don't have the capacity or it doesn't make practical sense for us to take those cases in-house, especially when someone is in immigration court. So if you have no experience, I am very happy to hold your hand the whole way and help you as much as someone may, as a practitioner may need. We also do have a number of documents written, um, resources and support, brief samples, things like that, that we can absolutely share with you.
Fantastic. Um, and if someone has more limited time in their practice, is representing a stateless person for purposes of filing a FOIA, a USL, United Stateless priority that a pro bono attorney could also help with?
Yes. Yes, that is great. In fact, one of our very closest partners, Hyas, is going to be having a training on how to submit FOIAs, and you can join their list also for submitting FOIAs. So we actually do send when we have individuals who need to get FOIA, and for anyone who doesn't know, that's Freedom of Information Act requesting all of your background documents on the case. So when somebody needs a FOIA, all of their documents, we've started a new clinic with Hyas where we send those individuals to Hyas, and then they will partner with a pro bono attorney. But also we can do that, directly as well. So if you are interested in taking that, there's a training that Hyas is putting on. That's on Tuesday, March 28th from 2:30 to 4 p.m. Eastern. And maybe I will send that registration link or have that sent out to the participants here after the presentation, if anyone's interested.
Fantastic. I'm sure many of our listeners today would be interested in learning more about that. Um, and just in our final kind of last minute here, are there any closing remarks that Karina, you or either Karina or Samantha would like to make as we wrap up?
I'll just say thank you so much for your attention. Thank you so much for caring about this issue. Thank you so much for representing and caring about stateless individuals. We will also be announcing, we don't have the details yet of that second training that we've mentioned that will go into more depth, more geared at folks who are already or interested in representing stateless people, and will give more practical advice on how best to represent a stateless client. And we will announce that quite soon and make sure everyone who registered here gets that information.
Fantastic. Well, thank you both so much. And that's all the time that we have for today. To the audience, please stay connected for instructions to get your CLE certificate and wait for the evaluation to appear on your screen. And to our faculty for this program, Samantha and Karina, thank you very much for sharing your expertise with us. On behalf of the ABA, I'm Stephanie Baez, and I'm thanking you all for joining us. I'll now turn you over to our operator for some additional information.
Thank you. On behalf of the American Bar Association and the Commission on Immigration, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at americanbar.org. Thank you, and please click on the evaluation link. We value your feedback.